Today, the rental market in England changes completely. From the 1st of May, Section 21 is abolished. No-fault evictions are gone. And in their place, a new system begins. One that will reshape how landlords regain possession and how tenants live in rented homes. This is the Renters' Rights Act. And it doesn't just change one rule, it changes the entire framework. From today, fixed-term tenancies will no longer exist in the way people are used to. Instead, all tenancies move to a periodic system. That means tenants can leave with notice at any time, and landlords must follow a different legal route to take properties back. Section 21 is removed completely. In its place, landlords will now rely on revised Section 8 grounds. These include situations where rent arrears have accrued, and possession proceedings is the next stage in the arrears recovery process. But unlike before, possession is no longer automatic. It requires a legal ground, evidence, and in many cases a court hearing. Notice periods are also being extended. Tenants will have more time before they are required to leave, and they will also gain new rights to challenge rent increases if they believe them to be excessive. Alongside these changes, a new complaint system is being introduced. A private rented sector ombudsman will be set up to resolve disputes between tenants and landlords. And sitting alongside that, a national landlord database will outline legal obligations, while giving tenants greater access to information about who is managing their home. Enforcement is also shifting. Local authorities will see expanded powers, with higher civil penalties, new investigatory duties, and a requirement to report on their activity. Rent repayment orders are being widened, and the maximum penalty is set to double. There are also changes to how properties are marketed. Landlords and agents will no longer be allowed to accept offers above the advertised rent, and they will be barred from discriminating against tenants with children or those receiving benefits. At the same time, property standards are tightening. The Decent Homes Standard will now extend into the private rented sector. And a WAB's law introduces defined timeframes for dealing with hazards such as damp and mold. For those working in the sector, this is not being seen as a single reform. Some argue it is part of a longer pattern. Years of regulatory change, increasing compliance, and rising operational pressure. There are also questions about capacity. With Section 21 removed, possession cases will increasingly rely on Section 8. That means more evidence, more structured claims, and potentially more cases entering a court system that is already under strain. There is ongoing debate about whether the courts can cope, and whether changes will be needed to deal with the volume, including the possibility of handling some claims on paper. What is clear is that the balance of control is shifting. Where once landlords relied on a process that appeared straightforward, possession will now depend on meeting legal thresholds from the outset. For tenants, the changes bring stronger protections. More time, more rights, more oversight. But for both sides, the system becomes more complex. And as these changes take effect from today, the real test begins. Because while the law has changed significantly, how it works in practice, in homes, in courts, and in communities, will take time to unfold. Thank you for watching Tenancy Talk.